Okay, so we're back. I had someone else needed to use this room, and so they walked in, and so I had to cut the video at a little bit further than halfway through, but we'll go ahead and pick up where we left off. So we were on section 22, risk of loss or neglect, and basically this just states that if something should happen to the property, if it should catch fire, if it should become flooded, or some other type of catastrophic event were to take place with the property, the risk of the loss lies and remains with the seller. So the buyer isn't still obligated to purchase the house if it's been burned down or something like that. Section 23, walkthroughs. So there are two walkthrough periods that are outlined in this section. Not a lot of agents are aware of this or use the first walkthrough because it's fairly new in the contract, and I think a lot of agents are just kind of set in their ways. But the first walkthrough is within X number of days, generally 3. So it's generally within 3 days of the time frame that was outlined in the inspection contingency addendum, and we'll get into that form a little bit further on in the course. But during the inspection contingency, when you deliver the addendum, there is a section that says seller will make these repairs within X number of days. Once that time frame, if the seller agrees to do those repairs and that time frame has passed, the buyer has X number of days to go through and review specifically those items. So if they asked for the HVAC to be serviced, one way that you can be certain that that actually did take place is just ask for a receipt of the invoice. Or if there's something a bit more tangible, like a broken window was supposed to be replaced, well, you can always get an invoice for that, or you can actually go out to the property, do a physical inspection, and make sure that those changes and repairs were made. The second walkthrough is generally within about 3 business days prior to close of escrow. However, I think that's how it's written in the contract usually. However, in practice, it's usually done like right before or right after the buyer does their final signing. So they'll go to title and sign their closing docs and head out afterwards and go do the walkthrough. Or they might do that right before. A lot of buyers like to do it before just to make sure that the house is the same. And I always like to explain to my clients, whoever we're buying the house from, they're moving out. The house is going to be in shambles. There's going to be moving boxes everywhere. Don't worry, we'll put provisions in there, and I often will put a provision in my purchase and sale agreements under other terms and conditions that the seller will have the property professionally cleaned and provide invoices for that. And if the carpets are in bad shape, then also put that in there, that the carpets are cleaned professionally, and provide an invoice of that work that was done. But I always like to tell my folks, we're checking to make sure that the property is in substantially the same condition as it was at the time of our offer. So make sure that we're here just really to make sure that they didn't put new holes in the walls, and they didn't swap out the really nice refrigerator for some cheap one if it was included in the sale, or similar with the other appliances in the house. Just want to make sure that it's still more or less the same property. Item 24, singular and plural. These terms include each other when appropriate. That's pretty straightforward. If an addendum says buyer to do X, but there are 2 buyers, the assumption is it's referring to both buyers. And same with sellers. Foreclosure notice. So section 25. This just basically says that if there are foreclosure proceedings taking place on a property, that must be disclosed to the buyer. The buyer can't not be aware that foreclosure proceedings are underway, because frankly, if those foreclosure proceedings were to complete, even in the midst of an escrow, even in the midst of the transaction, well, now you have a new seller, and your purchase and sale agreement is invalid at that point. So definitely, if you are representing buyers, you would want to know if the property is under any foreclosure proceedings. Section 26, it's just a general disclosure about mechanics liens, and it kind of just talks about how mechanics liens work, and it's kind of a extraneous information to have in the purchase and sale agreement, because almost, in my experience, at every closing table, the title officer, or really the escrow officer, almost always mentions, hey, this is how mechanics liens works, so if you ever get any work done on a property, make sure that you pay it in a timely fashion, and if it's over $2,000 worth of work that's being done, then you need to make sure that gets paid. Sales price information, section 27, it just says sales price information is not confidential. However, in the state of Idaho, this is a non-disclosure state, or non-mandatory disclosure state. So I always tell my clients, if they're going to be applying for a homeowner's exemption, they will want to do that within the weeks after the closing. I always tell them at the county office, they're going to try to find out how much you paid for the house, so that they can tax you on that. But you don't have to tell them. So just don't disclose. Just say I'm not looking to disclose that at this time. And the assessor will determine the value, and it's generally low. It's generally about 10% below value, which is good. It saves your clients money on their taxes. So transmission of documents. Basically, this just states there's going to be documents going back and forth between a lot of different parties, between the buyer and their agent, the seller and their agent, the title company, the transaction coordinator, the loan officers. Transmission of documents can be done via mail, via hand delivery, via email, via fax, and those are acceptable forms of transmission of documents. Those documents are still legally valid. There is a wire transfer warning. There's wire transfer warnings in almost every single contract, every single document. It's in the buyer's representation agreement, as you know, we just went over that. It's also in the seller's representation agreement. It's also in the purchase and sale agreement. Just be careful with doing wire transfers. Item 30, straightforward, defines business days. Business days, Monday through Friday, 8 a.m. to 5 p.m. And they do not include holidays. So any legal holidays that are recognized by the state of Idaho. So you might have a federal holiday that Idaho doesn't recognize. That's still going to count as a business day. But if Idaho recognizes it, it's not going to count. So this does matter. If you have 5 business days to perform your home inspection, and on day, so let's say the contract is executed on a Monday. Well, generally, so that period of time, that 5 business days, doesn't start until the next full business day, and so business day 1 would be Tuesday, and then you would have Wednesday as 2, Thursday as 3, Friday as the 4th business day, and then let's say that the following Monday is Martin Luther King Jr. Day. Well, that's a holiday, and so that's not going to count as a business day. So you actually have until Tuesday to deliver your inspection contingency notice to the seller. So I've had that happen before, where agents have called and said, hey, your inspection time frame is up. And I'm like, no, we had a holiday in there. But pay attention to that. That is important. Calendar days are defined as literally just your days that are on a calendar. So if you have a time frame that is calendar days, then that means that's how many days you have, and holidays aren't gonna count. They're all just gonna be included if you're going by calendar days. So make sure you note that distinction. Item 32, just attorney's fees. This is pretty boilerplate, but it basically just states that, you know, if there is, if either party, the buyers or the sellers, initiates a lawsuit of some kind regarding the real estate transaction, then the prevailing party, whoever wins the lawsuit, will have their attorney's fees paid for by the losing party's fees, by the losing party. So if I sue somebody and I lose, well, they had to defend themselves in court against me, against my, you know, claim that was erroneous or unnecessary or inaccurate, and but they had to pay for their attorney, and so Idaho wants to limit frivolous lawsuits, and so this is one method of doing that, is saying, look, if you initiate a lawsuit and you lose, you're going to pay for the other party's attorney's fees, and that can get very expensive. So important bit of info there. Okay, so section 32, default. There are two different ways, two different kinds of default in a two-party transaction, obviously. The buyer can default or the seller can default. But default doesn't just mean that the contract failed. I mean, the contracts fail all the time and are terminated on a pretty consistent and regular basis. However, a default means that the buyer or the seller failed to consummate the contract, failed to execute outside of a protected contingency. So, buyer gets cold feet at the closing table. Buyer just flat changes their mind. They find another property and write an offer on that one instead. That is a default. Now, if that were to happen, if the buyer defaults, well, there's a couple of options. So, if the earnest money has not been earmarked as non-refundable, which is pretty rare that it would be marked as non-refundable, if it's just a normal transaction and the buyer defaults, well, the seller has rights to that earnest money. However, the costs incurred by the seller, due to the default, might be way more than the $1,500 of earnest money or $4,000 of earnest money, whatever it is. So your sellers need to know that if they take the refundable earnest money, that is considered liquidated damages, and that is their sole remedy. So they are not able to go after the buyer for any other costs incurred by them. So, if you have a seller that is out $10,000 of their own earnest money on another transaction because the buyer of their house defaulted, and that buyer had $1,000 of earnest money, well, it's probably not going to be in their best interest to take that $1,000. It's probably going to be in their best interest to push for liquidated damages. Go ahead and refund the $1,000 to the buyer and pursue it outside of the contract, whether that be through arbitration or court. If the seller defaults, it's a very different type of situation. I've personally experienced it one time, almost experienced it. We got to the end and the sellers were refusing to sign. They just got cold feet. I can't speak to their mindset at the time, but they just decided they didn't want to sell. And so I had to let them know, hey, look, the earnest money is going to go right back to the buyer, and that's not considered liquidated damages. The buyer has incurred a lot of costs. They've paid for a moving company. They've done a lot of things here. This was the day of closing that they decided not to sign. You guys are open to being sued for specific performance. and this is going to cost you guys a lot of money because you guys will lose. And you know, you don't want to generally give legal advice. However, this was a pretty clear seller default, and so they would have to pay for their own attorney. They would have to pay for the attorneys that were representing the buyers, and they would also have to pay damages. And so in the end, they actually did sign an addendum extending closing by 1 day, and then they went down to the title company and signed. Thank goodness for that. But so we'll deal with that a little bit more in depth on the seller's representation agreement. But an earnest money dispute or interpleader, this is section 34. So this basically just states that both the buyer and the seller are going to agree that if there's any type of dispute over the earnest money, it's gonna the responsibility of determining where the earnest money is gonna go is gonna be the responsible broker, which is outlined on page 1 of this contract. Now, let's say it's not super clear where the earnest money should go. Maybe there's conflicting, ambiguous terms, and contingency deadlines were kind of muddy. Well, the broker might look at it and go, you know what, I can't, you know, beyond the shadow of a doubt say the earnest money should go here or there. Then they can refer it to an interpleader. This section basically just states that is the next step if the broker is unable to determine where the earnest money is supposed to go. Counterparts, section 35, this just is a part of Idaho contract law. Agreements can be executed in counterparts, meaning if I have the, you know, a copy of the contract and a second copy of the contract, they're identical in every way. You know, maybe one buyer is in Washington State and I send it off and she electronically signs it, and let's say the husband is here, or their spouse or partner is here locally in Idaho. Well, they can physically come into my office and sign it as well, and now we have execution because they have both signed it. So it doesn't have to be on the same piece of paper. It doesn't have to be the same digital copy. If they're identical and they both signed it, then that's one contract. So not applicable, defined. This is pretty straightforward. I don't think I need to really get into that. Severability. This clause right here allows us to make amendments and addendums to a purchase and sale agreement or to any of the real estate contracts, and have the contract still remain valid. So if there's any part of it that needs to be changed, you know, for various reasons, they could be legal reasons or just unenforceable reasons. Someone got COVID and got sick, or something happened and we weren't able to make the closing time frame, so we needed to extend out by a couple days. This severability clause is what allows us to do that. Representation confirmation. Make sure that you're filling these out correctly. If you don't have a buyer's rep for your buyer, well, you should probably get one. But if for some reason they refuse to sign one, then don't put that you're their agent. Don't put this is item 38, but in section 1, you would not put A, you would put D. The brokerage working with the buyer is acting as a non-agent. Also, if you are going to be doing limited dual agency, then make sure that you're checking that appropriately as well. So if you are checking B, like for example with our brokerage, we work without assigned agents. So if section 1 is B, then section 2 is going to be B as well. Those two can never be conflicting items, B and C. So if it's C on 1, it's C on 2. If it's B on 1, then it's B on 2. Let's see here. Item 39, closing. So one thing that's important about this section is that it starts off this clause with on or before the closing date. Everything has to get over to title. Funds need to, if they're using financing, then the lender needs to release the wire and release the funds to the title company. All of the documents have to be signed, and the warranty deed needs to be complete. Basically this just states everything has to be done prior to the actual closing. Closing means the date on which all documents are either recorded or accepted by an escrow agent and the sale proceeds are available to the seller. So you might sign on a Tuesday, but the wire cutoff time is generally around 3 p.m. Maybe it's 2 p.m. Between 2 and 3 p.m. Depending on the bank that you're working with. But after the wire cutoff time, maybe you guys sign. Maybe your client signs at 1 o'clock, and everything is done. But the lender doesn't get their docs from title in time to release the funds for the wire transfer. Well, then the closing is actually, the signing took place on Tuesday, but the closing is not going to happen until the next day. Sometimes if your contract stated that the closing was to be on or before that Tuesday, then you're going to have to do an addendum and push the closing back a day, even if it's just to get to the next morning. But you can always close early, and you can close early without an addendum because the closing is set to be on or before the date that you guys have agreed on. So sometimes that happens. I've got a transaction right now, we're closing a week early because it's a cash buyer. We didn't have to do any addendums or anything, just had to call the title company and say, hey, all of our ducks are in a row, we're ready to schedule signing, and we're going to be closing in 2 days. So the closing company and the title company are the same here in Idaho. If a long-term escrow collection is involved, then the long-term escrow holder shall be, for the 99% of your transactions, this is going to be NA. The only time that you're going to really be using a long-term escrow and collection is if the seller is acting as the bank or they're doing an owner carry. So let's say the seller owns a property outright, and they want to sell to a buyer. Well, and the buyer is unable to obtain financing, due to credit issues, or maybe they're a private contractor and they've only been doing it for 18 months, so they don't have 2 years of tax returns, which is what a lender would require. But they have a substantial down payment, then you would do then if the owner was up for it, then they could do an owner carry. And there's a separate contract for that. But basically, the seller and the buyer would negotiate an interest rate as well as a balloon payment date. And so what that basically means is, let's say buyer is going to purchase this property at an interest rate of 4.5%, amortized at 30 years, with a balloon payment on month 36. So the payment is going to be as if it was amortized at 30 years, but by the end of the third year, the loan needs to be paid off. And so generally, it's a great option, especially if you have a business owner, someone that has 1099 income, but they don't have the 2 years of tax returns. An owner carry can basically secure the property and take possession of the property, and as soon as they're able to get their financing in order, then they go to a bank and they obtain a mortgage, and then they pay off the seller. So, however, those typically do need large down payments because there's brokerages involved that need to get paid. The seller usually wants the incentive. They're going to want their funds, a chunk of funds, and there's title companies and things like that. So yeah, just a little side info there. Section 40, condition of property upon closing. Upon closing, buyer agrees buyers purchasing the property in as-is condition with all faults and with no further repairs required, subject only to the representations and warranties stated herein or unless otherwise agreed upon in writing by all the other parties, and buyer will assume all obligations with respect to the property. So when I've had this happen before where a buyer is like, we don't need to do the final walkthrough. Make them do the final walkthrough, because if they're, as of the closing date, if there's anything wrong with the property that they would have seen doing a walkthrough and they chose not to do it, that it's tough luck. Like, as of the closing date, this is yours now. Do a final walkthrough with your buyers. If they absolutely can't, and they ask you to do the final walkthrough for them, this is a personal decision that you would have to make. My experience has told me that that's a pretty terrible idea. I would say no. I can't do the final walkthrough on your behalf. However, if you have friends or family in the area, then they can do the final walkthrough on your behalf, but I'll just need it in writing that is the representative that's going to be doing that on your behalf. If they can't do the final walkthrough, send them something in writing. It can be an email, but something, and say, I need you to respond to this so that I know that you got it, but something that states you guys are choosing not to do a final walkthrough against my advisement. So yeah, that's an important thing. Possession shall be, this is section 41, possession. Buyer shall be entitled to possession upon closing date or another date in the future, or, well, it can be before or after closing. I've seen it all different kinds of ways. And that's, we'll get into that in the miscellaneous contracts, but generally the buyer shall be entitled to possession upon closing. And then the prorations, generally those are to happen upon closing as well. That means that taxes, utilities, if it's an investment property, rents, anything like that, any funds due from the owner of the property or to the owner of the property will be prorated as of the day of closing. Assignment, section 43. This agreement and any rights or interests created herein may or may not be sold, transfers, and otherwise assigned. It's pretty uncommon that people assign contracts or sell contracts, but it did happen. It used to happen a bit more, where I used to work with an investment brokerage that they would write contracts on multifamily properties all the time, and they had a large pool of buyers, and so we would negotiate these purchase prices on these multifamily properties, and then that particular investment company would fish it out to their clients and see who wanted that property, and that person had the right to purchase the rights to purchase the property. It's kind of interesting, I know. But for the most part, you're just going to put may not be sold, transferred, or otherwise assigned. Unless your client specifically instructs you to make it assignable, you won't by default. 44, this just says that everything that's outlined in here is the entire agreement. You guys don't have any side contracts going on. No double contracts, that's a no-no. 45, time is of the essence, as we all know. A deadline's a deadline, and if we miss a deadline, tough luck. I cannot tell you how many times I have received an inspection contingency notice from a buyer's agent a day late, a day after the inspection contingency is over, and they're asking for a lot, and I'm like, look, dates matter, and you missed it, and through whoever's fault, I don't know whose fault it is that you guys missed it. Maybe you guys weren't paying attention, couldn't get an inspector out here or something, but you should have asked for an extension on your inspection contingency officially with an addendum. We could have done that, but you guys didn't do it, and so now my seller is not obligated to make any repairs at all. You guys are moving forward in the transaction, and I try to be reasonable, because you're going to be working with a lot of these agents for years and years to come, and you don't want to burn bridges, but you do have to protect your client's interests. So you might state, hey, send me over the list, send me over your inspection contingency, and I'll provide it to my sellers and see if there's anything they're willing to do. If there's something major, I think we'll do it. But dates matter. They are important. So I always try to let my clients know, like, we can't mess around on scheduling the inspection. We can't mess around on you guys paying for the inspection report, and letting me know the disapproved items. Like, we have to be on Johnny on the spot on this. So authority of signatory, item 46, section 46. This is really only going to be applicable if the buyer is a corporation, an LLC, or a trust. Basically, this section just says the person signing on behalf of the purchaser has the legal right to do so. So, for example, if it's a two-member LLC, then that LLC requires that both members sign, and it would be in their operating agreement. If it requires both members to sign for any real estate purchases, well, you need to have both, and so, but it's also not your responsibility to go looking through LLC documents to see. This section right here just says that the buyer, whoever's going to be signing this document, is warranting that they have the authority to make this purchase on behalf of this trust or corporation. Section 47, acceptance. This is just the time frame for how long this offer in its current state is good for. Once it expires, it expires. There is a section at the bottom of the next page that says late acceptance. And if you're in a multi-offer situation, you might give the seller a little bit more time. Personally, I don't even know why the late acceptance thing is even here. If you've put on the acceptance that you want a response within 24 hours or the contract fails, signing it down below that, well, we'll give them an extra couple days if they don't, kind of takes all the teeth out of your statement. So but it's there, so at any rate. And the last page is just signatures and information. A lot of agents try to kind of keep their clients' information secret, and you are required to maintain confidentiality. You can't sell your clients personal information like their phone number and email. However, this is going to be going to the title company, and this is going to be going to the lender, and title's going to need to talk to them, and the lender is going to need to talk to them, and just put their contact info on this last sheet, because it is such a pain. If you don't, title's going to be reaching out to you. Hey, how do we get in touch with buyer A and buyer B, and then what's their situation? And they're going to be asking for payoff information. They're going to be sending it to you. Just give them your client's contact information. It'll just make your life so much easier. yeah, so pretty much does it on the RE21. There's just a couple of additional things that I'm going to toss out here. If the buyer has an active real estate license in the state of Idaho, it does need to be disclosed. If you are related to the buyer, that has to be disclosed, just like on the seller side. If the seller is an agent or are related to an agent, related to their agent, then that does need to be disclosed. And then you'll notice on section 48 here on the last page, underneath buyer signatures, it says see attached buyer's addendums, or see attached buyer's exhibits, and it does specify the number of addendums or exhibits that are attached. This is, this can be helpful if you're purchasing a property that has a really lengthy legal description that won't fit on the RE21. The legal description, in the past I've done, I've had a really, really lengthy legal description, like a full page legal description, because it was up in Garden Valley, and it was, the meets and bounds and townships and all the fun stuff. So we just attached that as an exhibit. So you can put that on there. Now, when you submit an RE21 to the listing agent, and they send it back to you signed, always check that, and in all likelihood you're probably going to have spoken with this person, and so you'll know if there is a counteroffer. But there's a box under section 49 that basically says the seller agrees to the terms. But then there's a box here that says signature subject to acceptance of attached counter offer, and counter offer includes addendums and exhibits, and those need to be numbered. I have personally made the mistake of sending over a counter offer on a listing that I had. This was years ago, but it's the kind of mistake that you only make once. Or should only make once, if you have to make it at all. But got an offer. We had some terms that we wanted to counter. It really wasn't anything major, but we drafted a counter offer. My client signed it. They also signed the purchase and sale agreement, sent it over, and thankfully the agent that I was working with is an agent that I know and have a good, mutually respectful working relationship with. And she said, she called me and said, hey, I got your signed offer and counter offer, but you didn't check the box making it subject to the counter offer. So she said, I'm sure that you meant to do that, and so I'm just going to shred what I have, and then maybe you have your clients check that box. And that was really a class act kind of move there, because technically they had us dead to rights. We were stuck with the original terms of the contract, and our counteroffer, we had nothing to fight with. And I've been on the other end of that as well, where an agent has sent one over and they didn't check subject to the counteroffer, and I will let them know, hey, look, this is a mistake that you want to fix. So make sure that that you're checking that box if you're representing. Honestly, if there's counteroffers going back and forth, make sure that the boxes are getting checked properly. So yeah, woof, that's a lot. That's a lot of contract there. But practice this, practice explaining it, go through all the terms and make sure that you know it, because the one time that someone asks you what something means and you don't know, you're just going to lose a lot of credibility in their eyes. So we don't want that to happen for any of the agents, at our brokerage or otherwise, because it's bad. It just looks bad for our industry as a whole. We want to project professionalism and knowledge, and so yeah, best of luck with your purchase and sale agreements, and we'll get you on the next. We'll get on to the next contract.